affidavits keep coming and you quickly just sometimes write and this doesn't really.
Yes, in 2025.
Yeah, luckily your lordships have that experience. Your lordship immediately corrected me. So, but in fact, what your lordships are saying that the difference would be more than what I've indicated, not less. So it's sorry. Meeting number. Let's do it now.
There can't be an entry below 35.
Yes. Minimum is 35. Just see, may I just, now that we are mulling on this issue. Oh, Kerala, 42 and 49, no? 49. No. Okay. Yeah, correct. It's a much bigger difference. One of the examples given by my...
You see, this entire facts which you are referring to, this only highlight the anomalous situation.
Correct.
According to you.
My lord.
That a kind of a explicit discriminatory or anomalous situation between direct recruits versus promoter.
My lord.
Those were departmental, this limited
LC
entry, 25%. To whom we can, just on loosely, we can call them semi-direct recruit.
Right. Because they are getting a, yes.
So advantage. They still might have an edge or advantage of seniority. Might. Depending upon that, what time they compete and what time they get acquire eligibility and enter.
That's right.
Now this entire anomalous situation, what is the ultimate recommendation?
So, would your lordship want me to come to that first and then come back to it? Very well, I can mention that. But before I could do that, can I just mention two aspects, which, my lord, since your lordships are on LCE right now, just now, and also, my lord, recently we had a judgment of a constitution bench which says that even, my lord, serving civil judges after 7 years can take the direct recruit examination because the experience there is actually much more than that of an advocate of 7 years. That's what your lordships have said. So, my lord, one of the points that my learned friends have said, and it's a point worth, my lord,
therefore, balancing of seniority is now also important because of that judgment.
Right.
If you give so much incentive to the seniority for the direct recruits,
correct,
our junior cadre officer will start only working for competing.
And they will not be interested in deciding cases, they will study for the examination.
They have a crisis in junior division level.
Exactly. So, you will spend 7 years preparing for the district judge direct recruit examination rather than doing, because then you are not bothered about your ACRs, etc., because you are only interested in taking the direct recruit examination. But, please see two examples that I am giving. Lord, one of the things that has been pointed out, it's certainly something I should mention straight away, is that LCE, which your lordship pointed out, and even the direct recruitment now gives some kind of equivalence to other people, which would include promotee judges. Now, the way they've said is this, that let us say, the case where a person graduates at the age of 23 years. Let us, take an example from law college. Then, that person will spend 3 years practicing as an advocate as per your lordship's judgment for 26 years. And then, as per your lordship's judgment, LDC, they can take after 7 years minimum. So, let us say 26 plus 7, 33. So, they are saying that at the minimum age, if you clear everything in the first round, you will at the age of 33 itself become eligible to become a district judge.
So, 35 is the 35.
But so 33, but you take it to, so therefore you have no disadvantage. I was coming to that. 33 through LDCE, 33 to LDCE, but let us say you are appointed at 35 only. So the argument is there is no disadvantage. I am just dealing with that argument. Next is, my lord, let us take a case of a civil judge who after 7 years, as per my lord, your lordship's judgment in the review in Dheeraj More, takes the examination and clears it. So, my lord, in his case also, he would have joined at the age of 23. Let us say, my lord, finished law at 23, 3 years, my lord, of advocacy practice, and then, my lord, 7 years. So that takes it to 35. So
we have made it that even in their case,
yes,
they can't get in before 35.
they can't get in before 35, but the argument that is being made is that therefore there are enough avenues for you through LDCE or through us for a civil judge to take the direct recruitment examination to come in at the age of 35.
And
now,
so
the answer to this, let me give the answer. Sorry.
So their condition would be, whoever are meritorious amongst the promoting, they would have already made it by either through LCD or through the direct recruitment.
Right. So that is one of the arguments. Now, but please see the other side of it. 50% of the entire cadre is not promoted district judges. We are dealing with 25% LCE and assuming that the entire 25% is filled up. Your lordships have seen that in that matter when your lordships heard, hardly anyone was taking LCE. Now they will take because of the incentive. And my lord, you are assuming that every civil judge after 7 years will clear the district judge examination. So for 50%, we are dealing with the 50% of the cadre here. So, my lord, for them, the seniority and, my lord, promotion is a very important aspect. That's what I'm trying to say. So, my lord, to say that they've got opportunities, even after taking those opportunities, 50% of the cadre will still remain regular promoting cadre. So, we have to, so your lordship may think of that that's what I'm trying to say, bro. Now, so, my lord, tell your lordships what my suggestions are and then I'll come back to this. Would your lordships come to, my lord, to page 48? I've dealt with the case of the same, 48. I've given 4 suggestions in the alternative, etc. Try to be, my lord, as even-handed and fair as possible. My lord, just have a look at it. My lord, may I read suggestion 1 at page 48, Roman 1. The additional experience as judicial officers constitutes a reasonable and justified classification on the basis of which promoted district judges can be classified as a category who ought to be granted a quota for their effective representation at the post of district judge selection grade, district judge, super time scale, principal district judges. Creation of such a quota satisfies the twin test of classification based on intelligible differential and reasonable nexus of such classification with the object sought to be achieved. Therefore, creation of such quota is permissible in terms of so-and-so. It is thus suggested that for appointment to the post of so-and-so, now, my lord, here, I'll just make there's a nuance here, which I'll just point out, to the post of district judge selection grade, district judge super time scale, principal district judges, a quota of 1:1 for promoted district judges and direct recruit district judges may be created. Principle of merit cum seniority can then be applied within the said quota. So what the suggestion finally is that even for that 25% direct recruitment, you have a 50% quota, and for that 75% entire promoting cadre, you have 50%. That your lordships can of course make it 75, 25, 25. Also, some of my learned friends on this side are arguing that. But here, my lord, your lordship will have to see one nuance, that this district judge cadre has, my lord, 50% judges at entry level, 35% at selection grade, and 15% at super time scale. So, my lord, if we let us assume for a minute that this 1:1 quota is to be applied, and we apply it to both selection grade and super time scale, then there will be no entry level direct recruit district judge left, because 17.5% plus 7.5% will go into the next 2 posts. So, my lord, my suggestion here therefore will be to have that at the super time scale.
Only.
I hope I've made myself clear. My lord, let's say there are 100 posts in the cadre. So there will be 50 my lord entry level, there will be 35 selection grade, and 15 my lord super time scale.
Mr. Bhattacharya, that 25% departmental examination,
Yes.
the 25% quota, is only meant as an incentive.
Yes.
For the officers who we suppose that they are meritorious enough, that they can, through competitive exam, they can occupy those 25%.
Right.
What will be the incentive for them left if you apply this ratio in principal district judge or selection grade? And
no, because they will still be they are still promotees. Of course, no, the incentive.
Therefore, why they should compete for 25%?
No, so
if ultimately this position is to be occupied solely on the basis of length of service, then what is the incentive left for them?
For the LC, yes.
25%.
No, then, my lord, you will be senior to a regular promotee in any case in the seniority list. You will have a quota, yes, but your seniority will be higher.
Then are you conceptualizing a situation
Yes, sir.
where the senior most person in the cadre of district judge, though he is senior most, but he will not get a super time scale or he will not get a selection grade?
No, I'm not visualizing that. In fact, I'm saying the opposite. I'm saying the senior most, suppose Milord, the LCE person, let's say Milord, there are two promoters appointed on the same day. One of them clears LCE at a younger age.
If on the same date they are promoted,
Yes.
nothing difficult. Because then you can say that promotees will have an edge over the department
Right.
appointed promoter.
My lord.
let us say. Then he can be assigned seniority. You can have kind of a roster point. You give first point to the promoter.
That's right. That's how the roster is also. Yes.
Third maybe to the direct report.
Correct.
That is one possibility. But what will be the incentive left for an officer?
Yes.
He will say, why should I work hard, compete, and try to qualify the exam when eventually, in terms of seniority or in terms of monetary benefit of a higher pay scale, I'm going to lose?
The benefit will be, in my respectful submission, this that suppose, my lord, there are two civil judges, senior division. One is junior to the other. The junior one passes the LCA examination. He comes directly into the cadre of district judges. He becomes senior to the regular promotee when he comes in. So, my lord, the seniority will be higher in the cadre in any case. The quota doesn't affect seniority. Yes. Right. What I was saying, just my lord, just to come back to what your lordship very rightly put to me. Firstly, my lord, at the entry level, we are not fixing a quota. So the LCE will anyway be senior. So entry level, my lord, will be as per roster, as my lord said. Only at super time scale will, my lord, the promotees get. Now that's one. Secondly, if I have just in fairness mentioned 1:1 as an amicus, but suppose some of my learned friends etc. are saying the quota should be 2:1:1. That is to say, 2 for regular promotees, 1 for LCE and 1 for direct recruit. Suppose that is accepted by lordship, then LCE again will get the same.
Ultimately, 2:2 only.
Yes. I am saying that, but ultimately I am saying that the regular promotees are the ones who suffer the most because being maximum in the cadre. Not coming to suggestion 2, which is the next page, page 49. Now here, Lord, it's the same as suggestion 1, except here we are saying something a little different. Alternatively, zone of consideration for appointment to the post of district judge selection. So please read this: zone of consideration for appointment of district judge selection grade and district judge super time scale should comprise of 50% officers from directly recruited district judges and 50% from promoted district judges. Thereafter, appointment would be made on the recommendations of the respective high courts on the basis of merit cum seniority. Thus, in the zone of consideration, 50% shall be senior most promoted district judges and 50% shall be senior most directly recruited judges. Now, suppose there are 10 posts. So most high courts have a system where the zone of consideration is 3 times. So let us say 30 officers, 30 judges will be considered. Now, out of which my suggestion is that in this zone of consideration, you will have 15 from the senior most promotee and 15 from the senior most directly recruited. After that, if the High Court feels that all 10 should be directly recruited judges appointed to the next grade, that is for the High Court to decide on merit cum seniority, or 5:5 or 10:, whatever. But this is the zone of consideration argument, so that at least somebody comes within the zone of consideration. Otherwise, they are not in the zone of consideration. If it's 3 officers to be considered for one post, then obviously because of seniority, etc., they're never in the zone. This will bring them within the zone. This is the second argument. So this can be an alternative to the first in case your lordships feel that this is a better one.
Mr. Marcus, your suggestion, second suggestion, in fact will create a cadre within a cadre.
Why is that? I'm sorry.
Because you are saying that the 50%, let's say there are 10 candidates eligible for a super time or a special selection grade. It would be 5 from the promotees and 5 from the direct recruits. So what would happen is at the district judge entry level, it's a common cadre.
Yes.
And if the second suggestion is adopted,
My lord.
then we are creating a separate classification, a cadre within the cadre of direct recruit judges as district judges and promotee judges as district
So,
judges.
with great respect, what I was trying to say is that they'll only be in the zone of consideration for being considered. Appointment can be of either of them, but they'll be the same. It's the cadre remains the same.
But for that, the list of seniority
Yes.
will be a different list of seniority for the district judges as direct recruit district judges and promoted district.
So that
That is your proposal so
No.
far as.
So that is not exactly my proposal. I'm saying that in the same
That will boil down to that.
Correct. Now, but that is exactly what in my fourth suggestion, the High Court of Andhra Pradesh has said exactly this.
We've seen it.
Exactly this,
But the area of consideration would be,
Yes.
do we create a stratification in the district judge cadre, which is an uniform cadre itself? We can definitely consider your first suggestion about quota in
Yes,
respect of the functional
That's the first-
seniority, functional position scales. But to create the cadre as groups will make it not an uniform, but a stratified cadre of district.
No, so I understand exactly what your lordships are saying, because then you are mixing up seniority in that sense. But my suggestion here is this is the only way in which if you are leaving it to the High Court to appoint a person and
It will also lead to a very anomalous situation
my lord.
where a person, because of this cap of 10 picking up from promoted, 10 picking up from direct recruit.
I'm not saying that.
No, zone of consideration.
Zone of
For zone of consideration.
Yes, yes.
10 you pick up from this side, 10 you pick up from this side, you merge them,
Merge them.
consider them, and then you promote them directly.
Whoever you want.
Maybe that throughout till the question of designation or promotion as the principal district judge comes, an officer who have been throughout junior will become a head of the district judiciary, and all persons who have been throughout senior to him will be under.
No, that may not necessarily be the case, because the High Court will consider it when we're making that appointment.
If you restrict the zone of consideration, then nothing will left for the High Court. Then it depends upon that if he qualifies, then you can't stop him.
I'm saying that presently the zone of consideration is such skewed in the other way. For that, if your lordship just comes to page 16, just have a look at the seniority list.
Probably you want to suggest the High Court will have to then very adverse responsibility of seeing that in which session division we are posting him and no person junior to him should be posted there. This will
No,
lead
no,
to
that I'm not saying. But
chaos.
Milord, eventually, this is so, but Milord, I'll just show to your lordships how it works. In practice, what the problem is. I'll just show that immediately after I finish these suggestions. I'll come to the chart. There's a chart, and I'll just show after this. The reason I've come out with this, that's just a suggestion for your lordships to consider. Milord, sorry. Milord, the third suggestion is in fact what the Justice Shetty Commission had said. So I'll read it out. Alternatively, it is suggested that this Honorable Court may accept the recommendations of the Justice Shetty Commission and grant weightage to promoted district judges for experience in terms of 1 year seniority for every 5 years of judicial service, subject to a maximum of 3 years. It is further submitted that these additional years of seniority may be considered as service in the district judge cadre. Thus, if a promotee district judge has been granted 3 years seniority as per aforesaid criteria, promoted district judge will require only 2 years of service in the district judge cadre for being considered for the grant of selection grade. This is the example I've given. It is stated acceptance of recommendation of Shetty Commission will require modifying or dispensing with 40-point roster system for seniority in so and so. Thus, it is respectfully submitted. It was respectfully submitted will address the issue of age disparity and additional experience of promoted district judge vis-a-vis district judge, direct recruit district judge. So this is exactly what Justice Shetty had said in 1999. The next one is what my lord has put to me, so I'll read that also. 4. Alternatively, this Honorable Court may consider the recommendation made by a committee of the Honorable High Court of Andhra Pradesh, which had recommended 3 separate seniority lists in respect of promoted district judges by regular promotion, promoted district judge LDCE plus direct recruit district judge in the ratio of their overall cadre strength of 50:25:25 and the selection of such higher posts in the cadre of district judges be made on basis of such seniority list. So these are the 4. One has come from the Andhra High Court, one is Justice Shetty, 2 I have put in, my lord, as my suggestions. Now, my lord, just to come back to page 16, I wanted to show your lordships a chart as to the what, my lord, the issue comes.
Page?
My lord, 16. My lord, we have been able to call out the seniority lists of some of the high courts. And here your lordships will see, let's say, my lord, Kerala. This is the seniority list. So Kerala has promoted district judge, promotee. So fair number of promotees at the top. In Patna, if your lordship sees, district direct recruit, then my lord, some promotees, then direct recruit, and then everyone direct recruit. So here we feel that if all these promotees will be older in age, my lord, to the direct recruits, and they will all retire before the other direct recruits, and the entire cadre at the top will become direct recruits. That is one of the things. Similar
in Patna, that happened because 94 district judges were taken at one go.
It is mentioned in the affidavit. I'll show that.
That is why it
So that could be the reason. Yes, sir. The reason is not stated obviously in the
happened.
affidavit.
For 7 years, there was no recruitment at all.
Yes, ma'am. Right.
In Bombay, I think out of 21 study was happening the other day, 18 or 19 are direct.
Yes. So all I'm trying to say is that this clubbing at the top is the problem. And the clubbing will happen because even if a senior promoted judge is there, because of a 10-year age gap, he'll retire earlier. Or a 5-year age gap, he'll retire earlier. So that's the problem. My lord, turning to page 17, my lord, I've just culled out a few, my lord, paragraphs of affidavits on both sides, saying against and for both. Now, if your lordship looks at 17, this is what state of Uttar Pradesh is saying. Para 25, bracket A. In the state of Uttar Pradesh, there are 70 district and sessions judges, of which 58 are direct recruit district judges. So, my lord, these are actually principal district judges. Although they've called them, but these should be principal. 58 are direct recruit district judges, 12 are promoted district judges. High Court of Allahabad in its affidavit stated as follows. Out of 257, 137 officers are promoted judges by regular promotion, 2 officers are promoted judges of LDCE, 118 are direct recruits. Out of 100 senior most officers, 17 are promoted judges, regular promotion, 2 are promoted judges LDC, 81 are direct recruits. Senior most promoted judge features at serial number 29 in the seniority list. Therefore, posts at serial number 1 to 28 are occupied by direct recruits. The High Court is saying. Now, my lord, similarly for Bihar, your lordships had said there's a reason for it, but anyway, I'll place it. Out of 622 occupied posts, 91 judicial officers are working as principal district and session judge, consisting of 5 promotees and 86 direct recruits. As per seniority list and detailed chart, there are 20 direct recruit judicial officers presently below the 91 judicial officers working in the rank of principal district and session judge, meaning thereby that after the retirement of 5 promotee judges in the rank of principal district and session judge, all posts in the said rank will be occupied by direct recruit district judges. This is what this is. Then some other, I will not read all of them, but just if your lordship would just come to Andhra, because Andhra gave that suggestion. So let's see what they've said fully. That's at page 19, page para J. The High Court of Andhra has stated in its affidavit as follows: whereas candidates appointed to the post of district judge by direct recruitment are generally in the age group of 35 to 40, thus promoting officers always become juniors of direct recruits. Despite having put in more than 25 years of service, promoting officers retire in the cadre of district judges as they are junior to direct recruits and do not fall in the zone of consideration, and the judiciary is deprived of experience at High Court level. As per present seniority list, first 17 members were selected as district judges by direct recruitment, and considering their age, the promoted district judges will not get the opportunity to be considered for the post of High Court judges, even though they have put in 25 years of service. In the light thereof, the committee has made the following recommendations. Distinct seniority list should be maintained for each category of district judges: 1 direct recruitment, 2 recruitment by LDCE, 3 recruitment by promotion. Recommendations for appointment of High Court judge should be made within these specified categories. Initial appointment ratio for district judges shall be consistently applied for subsequent appointment as principal district judges and further for High Court. The committee unanimously resolved to recommend that that 50% of appointments to the High Court from in-service officers should be drawn from the category of district judges who were initially appointed in the cadre of Civil Judge Junior Division, ensuring adequate representation. This is not the issue today before your lordship, but this is what the High Court has felt. Looking at the skewed ratio there, this is what the High Court committee itself is saying. This is not one of my suggestions, or this is not even the issue here today, but I'm just telling you, pointing it out.
You were told that even in state of Tamil Nadu also there is similar.
Tamil Nadu, I'll just show it. That's I think mentioned here. Just 1 minute. Tamil Nadu in their affidavit have said that 37 principal district judges, 27 are promotees and 10 are direct recruits. That they've said. At page 22, I've summarized it. In fact, page 20 onward, this is the view of some of the other states who have said that either the ratio is the same or promotees are more. So that also I put in. So, my lord, Chhattisgarh, Gujarat, Himachal, Jharkhand, Madhya Pradesh, Mizoram, Nagaland, Tamil Nadu, Sikkim, Uttarakhand, West Bengal, Delhi, and my lord, Jammu and Kashmir. So they are saying that in their states there are sufficient number, if not more, promotee judges. They have said that, so I put that also for your lordship consideration. Now, my lord, the other submission which I had made, which has been now set out at page 23, bottom, my lord. I'm just skipping over a few paragraphs because that we've already, my lord, covered that. My lord, para 31 at page 23. However, on account of the age by which promoted district judges are appointed to the post of district judge entry level, they suffer disadvantages in further promotions within the cadre. This is evident from the following. 1. First criteria considered by the High Court for promotion to district judge entry level to district judge selection grade is at least 5 years services district judge entry level. If a promoted district judge is already appointed at an age far more than direct recruit judge, by the time a promoted district judge completes 5 years to come within the zone of consideration, the direct recruited judge of a similar age would have already completed 5 years and be within the zone of consideration for district judge selection grade or even district judge super time scale. Though selection and promotion in the cadre or oblique promotion in the cadre is on the basis of merit cum seniority, to be within the zone of consideration is also a facet of seniority, since the said zone of consideration depends on a number of vacancies. For instance, with respect to Delhi High Court, the zone of consideration is as follows. Delhi has 1:5. For 1 vacancy, for 2 it is 8, 3, 10, etc. And for Assam, Manipur, Meghalaya, Nagaland and Tripura it is 1:3. The ratio, so 1:5 or 1:3. Next, my lord, if your lordship comes to my lord, para 33, which is at page 25. It is respectfully submitted that the benefit of limited departmental competitive examination, which has been given by this Honorable Court as an accelerated promotional avenue for Civil Judge Senior Division, has not led to an equalization in the district judge cadre. Now, this I'm saying before your lordship May judgment. This is obviously not, that's not taken into account. Limited quota for LDCE was introduced in 2002, but data shows that it has not led to a significant reduction in the average age of promoted district judges vis-a-vis directly recruited district judges, because 50% of the promoted district judges are recruited in the cadre via regular promotion, and in general, promoted district judges enter the cadre at a higher age. In this respect, paragraph 12.108 of the Justice Shetty Commission and the chart appended thereto becomes relevant, which I've shown it to your lordship. Since 2002, 75% of the posts in the district judge cadre have been kept for promoted district judges, being 50% by regular promotion and 25% by LDCE. However, the data provided shows no equalization in the higher posts within the cadre of district judges. It is then, my lord, I have given these examples which I have already given to your lordships. What is the minimum time that you take as a direct recruit promotee LDC? So that I have already shown to your lordships. And then, my lord, there are some paragraphs of this 2025 judgment of your lordships in, my lord, in the Dheeraj Moore case, which I have set out at page 26 for your lordship's consideration. Because to justify this quota, I am saying that there is a classification necessary, and that is a justified classification. One of the grounds will be this. May I read that, my lord, at para 36 at page 26. In a recent judgment, Constitution Bench of this Honorable Court in Rajneesh versus Deepa, in the context of eligibility of a judicial officer to be eligible for appointment as a district judge under Article 233 of the Constitution, held as follows in the majority judgment. Therefore, the question that is required to be considered by us is, if the purpose of recruitment is to get persons of necessary qualification, experience and knowledge of life, then as to whether the judicial officer who is in judicial service could be denied an opportunity to be recruited in the posts meant to be filled by direct recruitment. In that respect, we are of the considered view that it cannot be denied that experience a judicial officer gets by working as a judge can only work to the betterment of the district judiciary. The question that we would have to therefore consider in the present case is to whether such experienced persons having rich judicial experience can be permitted to participate in the process of direct recruitment for the post of district judge. I'm using this to say that that rich experience can very well also apply for this the present purpose that we have been arguing before your lordships. We are therefore in full agreement with those observations made by Shetty Commission, according to which, in order to promote efficiency in the cadre of district judges, young, talented, meritorious judicial officers should not be denied an opportunity. Experience of a judicial officer. As a matter of fact, some of the observations made in the subsequent three-judge bench judgments of this court in the cases of Sushma Suri and Deepak Agarwal would support the view that we have taken. In both cases, this court held that merely because by virtue of being government advocates, the candidates who were in employment, their rich experience of working as a lawyer for government cannot be ignored. It has further been held that they continue to appear for the government side, either on civil or criminal side, the rich experience would benefit the judiciary. As already discussed here and above, the experience the judicial officers gain while working as judges is much greater than the one a person gains while working as an advocate. Apart from that, before commencing the work of judicial officers, judges are also required to undergo rigorous training for at least 1 year. And then, Lord, I'm skipping 147, 148. We therefore see no reason to deny an opportunity to such young, talented judicial officers to compete with advocates and pleaders having 7 years practice in the matter of direct recruitment to the post of district judge. Then, Lord, 157. In that respect, we are of the considered view that for bringing the advocates and in-service candidates at the same level, it will be appropriate that rules provide an in-service candidate should be eligible for recruitment to the post of district judge directly, only if he has a combined experience of 7 years as advocate and judicial officer. Similarly, if an advocate in participating in the selection process and he was a member of judicial service in the past, then his experience as judicial officer also cannot be ignored. His experience as an advocate prior to joining judicial service, his experience as a judicial officer, and his experience as an advocate after leaving judicial service will all have to be taken together. Such candidate will be eligible only if he has a combined experience as an advocate or judicial officer for 7 years. So, my lord, this judgment is proceeding on the basis, at least for what I've quoted, that judicial experience is very valuable. And according to my submission, which I've made subsequently with some cases, that experience of a judicial officer from the civil judge cadre is a valid ground for creating a quota as a valid classification. That's the way I've tried to put it.
Mr. Michaels,
Well,
when the super time scale or the selection grade
Yes.
is done,
yes.
the experience as a district judge is taken into consideration, which is equal for the direct recruit as it is for the promoting district judge.
Correct. But the rules, sorry.
So the experience that you are talking of, the rich experience which cannot be denied, is equal for all of them.
No, my lord, what I'm trying to say.
You are trying to again add on the experience of a civil judge junior division.
Correct.
Which is a thing which has already been factored in when 50% of the district judge posts have been reserved for the promotee district judge.
No, so that.
So won't it be amounting to a double benefit?
No, my lord, it is not a double benefit for the following reason, that within the cadre, when a district judge, a direct recruit comes in, he's starting from zero. He's starting from zero. A civil judge is coming in, your lordship, it may be a ground for his promotion to the higher cadre, but his experience is not wiped out immediately on promotion, is what I'm trying to say. The experience still remains. It is tantamount to saying that whatever experience of 15 years you had is wiped out on becoming a district judge. With great respect, my lord, is my submission, ought not to be, my lord, considered in that sense, because a district judge, direct recruit, has zero experience. So you are in that sense equating zero experience with, let us say, 15, 10, 12 years of experience.
Like something. So Bhatnagar, there
Right.
is one another issue. Now, with the data you have presented as of now, in the cadre of district judges, all of them were recruited as junior division at the age of 27, 28. Because at that time, there was a prescription of practice. Now, for the last 1 decade, the things have drastically changed. They get into this thing at 23. We cannot go by this data alone. With 35. Last 2 decades. So that is, this data cannot be relied on. Because now the people are entering as a junior division at the age of 23. With the LCE also, at 35, they get a chance to go to the district judge level. The entire data would change.
No, so they get a chance to go into the district judge level by taking the direct recruitment examination. That's what your lordships are saying.
Direct recruit and LCE also.
LC also,
Both have-
but whatever stage, yes.
Now, when you say that the 50% are there, that is an informed choice they took
No, my lord,
to join as junior division.
I am saying, no, my lord, of course it's an informed choice, but I am saying that this data is of, at least from the year 2002 onwards, this data is not incorrect before, after that.
No, because the district judge cadre now has people who are recruited at the age of 27, 28 as junior division.
Yes.
That has changed now. For the last 2 decades, it's 23, 24.
No, correct. So in 2002 judgment, your lordships did away with the experience and again reinstated it now.
That is 3 years.
Correct. That's right. So let us say you come in at 23. I'm saying even then, if the disparity is so much, today the disparity will only increase. This data, my lord, whether we take it for 20 years, this data of disparity will be coming in at a younger age.
As Justice Bakshi said, you can probably provide a seniority at the time of recruitment. After that, how can it be?
No, but well,
Then you will be creating an artificial division between promotees, LCD, and direct recruits.
no, that artificial division, in my respectful submission, is a valid classification, because you're taking it, as your lordships have held this very judgment that I read out, that judicial experience is important. So if judicial experience is being taken for taking the direct recruit examination as being
Yes, Bakshi said that judicial experience is factored at the time of promotion, LDC and all that. Why should it be considered at the time
Correct.
of super time scale? Because then what is considered is the experience as a district judge.
So that is exactly what Justice Shetty also said. I'm not the only one saying it. Justice Shetty said it slightly differently. He said that you have to give them seniority in the cadre because of the experience. There also they've come into the cadre
But
immediately.
then that was not accepted.
Not accepted, but I'm commending it to your lordship. That considers the data of 1999 and came to this. After all, one thing is classification. The other thing is equalization also. If 50% of the cadre finds itself in a position,
Is there any critical analysis by you based upon a comparative examination of the rule regarding determination of seniority in different states or in different high courts,
yes.
that the anomalous situation between promotees versus direct recruit, is it originating as a result of the seniority rule or as a result of the manner of recruitment?
So it is, yes, I've given a summary of all the rules.
The experience showed that if you go by the ordinary principle of recruitment, there will be no heart burning among the promotees, because as soon as the promotee vacancy become available, the High Court will either go by merit cum seniority or the High Courts will go by this LDCE, whatever 10% or now 25%, earlier also 25%. The problem has most of the cases arisen only on account of the direct recruitment taking place say after 5 years, and then you are getting the roster points of direct recruit in a presumed either rota quota or implied rota quota. And then you are getting a placement in the seniority list where you are not even born in the cadre. And that is has been the largely the
So that is one issue definitely. But the age discrepancy is also a very important issue. Not how do we ignore that? Not let us take the worst case scenario.
Mr. Marcus, one issue also has to be taken into consideration as to why in 2002 judgment of the All India Judicial Association, the lateral entries were permitted. It was to infuse more talent at various levels of judiciary and the promotion at every level, including the functional scale promotions or upgradations,
Upgradation.
are essentially on merit and not only seniority, that is age. That cannot be, you have to factor in that.
I'm factoring that in, Lord. And I'm saying to your lordship exactly what Justice Shetty is saying, that although it is merit come seniority, but to come within the zone, you have to be senior enough. You don't even come within the zone.
That is something which is not a classification of an uniform cadre, that is district judge, but giving some more additional handicap or advantage
Some advantage.
to the promotee. That is well taken.
Correct.
But what is falling from us is that if your suggestion 1 or 2 of a quota in
Yes.
the functional levels are taken, or separate, as Andhra Pradesh has suggested, separate
Right.
lists are maintained,
Correct.
we are actually creating separate classified stratas in an uniform cadre. And
Which
that perhaps may be a problematic.
Which I agree with your lordships. If let us assume, my lord, it is
So if you want that age, there may be an area of exploring as to what additional advantages and weightages can be given to these promotees.
so, my lord. There is only one weightage, which is the weightage that was suggested by Justice Shetty, which is one of my suggestions.
So, Marcus, another issue is, as it is indicated to you by Justice Chandra, that see the evolving nature of the cadre. The cadre essentially started functioning for the last 2.5 decades.
Right.
It definitely gave an advantage to the direct recruits because of the age differential in the initial stages.
That's a submission.
And I can speak from my experience in West Bengal, today there is an equalization in the cadre. And the percentage of recruits from the direct channel and from the promotee channel are almost balancing out. So to make some changes,
My lord,
we must also bear in mind the evolving character.
correct. So I've placed those states also where there is an equalization, such as West Bengal. But, my lord, please consider, does this quota work against the direct recruits? If they are getting, let us say, 50% quota for 25% of the cadre, that actually works in their favor. Is my great respect.
You are dampening the merit factor. And you please bear in mind that the functional level upgradation is also merit come seniority.
It
and
is.
There we are, in fact, in some way restricting the Article 233, 235 powers of the High Court to make a merit-based selection.
It is restricted. That's one of my submissions, because otherwise, my lord, suppose it was not, it was fully being followed on merit come on the seniority.
Better boy है, उसको कोटा में
have you done any comparative analysis of the
Rules?
seniority?
So, yes, I have. There's a summary chart that is filed at the beginning of a compilation with every single High Court seniority rules, and they're all saying, my lord,
Between direct recruits and promoters.
correct. So there they are saying seniority will be, most of them or all of them, that seniority is determined by the 40-point roster. Now the problem is that, now let me tell you what's the problem.
So the 40-point roster must be creating problem.
It certainly is.
Direct recruitment takes place in 2025.
Yes.
Vacancies of the year 2020.
Correct. So that's
So that person suddenly occupies a post
absolutely
in
right.
2020.
Correct.
And those promotees in 21
Yes,
to
yes.
25, they
Right.
become junior.
So that is absolutely correct.
Therefore, that's why we are saying.
No. Your lordship's analysis is absolutely correct. That the roster systems, in fact, that's why I've said the roster system requires a rework.
हर स्टेट में रूट कौन सा है?
And, my lord,
Master failed because of emotional mismanagement.
That maybe there, my lord, that I
The
can't tell you.
appointments were not regularly made for
That's
the
right.
deputies.
That's right. If it was made, it
You see a situation
correct. my lord.
where unforeseen circumstances, including administrative roadblocks,
Yes.
disable the roster system. That does not mean that the roster system was incorrect.
No, my lord.
There requires some tweaking in the functionality
And
itself.
not only that, so the roster system, the other problem with the roster system is, I find it very hard to believe that we have a situation where the 40-point roster seniority, because seniority is by the roster, continues for all three grades of the district judge cadre. If merit comes seniority,
Creating the district judge cadre, once you come into the district judge cadre, it's an uniform cadre.
It
You
is-
have already been given your advantage in the roster system of 2:1:1, which is the general roster followed in every state.
correct. So that advantage or according to me, it's not an advantage at all, which is what I'm trying to show to your lordships, because the roster is a seniority roster. Anyway, my lord, I will just,
We have to conclude because.
yeah, so my lord, I'll just take 10 minutes to show one or two cases. I'm sorry, my lord, I got a little carried away in the, I'm very sorry, my lord.
Yes.
I'm sorry, my lord, I took too much time. Would your lordship just come to page 29? I've set out 3 or 4 judgments, which according to me, my lords, are relevant. My lord, now I will not read all of them, but I'll just, my lord, since time is short, I'm just going to, my lord, summarize them. The first judgment, my lord, which is Mervyn Coutinho versus Collector, and the next judgment, I've set out the paras for your lordships to consider later on, and the other, which is Roshan Lal, my lord, deal with a situation as to whether persons drawn from different sources into one integrated class can be further classified. So that's the question. So now these two judgments, my lord, in the case of one was the Customs Department case, and the other, my lord, was a train examiner's case, said that you couldn't. I've set out the facts also, my lord,
According to Mr. Basant, these judgments are against you.
against me. So now, therefore, my lord, I'm requesting your lordship to come to page 33, because this is the judgment which, according to me, another constitution bench, which is what I'm relying on. So for your lordship to consider. My lord, would your lordship later on just have a look at it? I've set out all the paras. If I read it, it will take too much time of both Roshan Lal and Mervyn, my lord. That's against me, correct? So I placed all the paras. Please come to page 33, para 40. In state of Jammu Kashmir versus Triloki Nath Khosa, a constitution bench of 5 honorable judges considered the question of classification based on certain identified criteria. This honorable court considered both the above judgments, which is Mervyn and Roshan Lal, in the context of the following question. If persons drawn from different sources are integrated into one class, can they be classified for the purpose of promotion on the basis of their educational qualifications? That is the issue for consideration before us. The case involved promotion to the post of executive engineers from assistant engineers. Under the rule in question, it was provided that those assistant engineers would be eligible for promotion who possessed a bachelor's degree in engineering or held the qualification of AIME and had put in at least 7 years service. Honorable Court held that such classification was permissible for first identifying and then distinguishing members of one class from another, as the classification rested on reasonable basis and bore nexus with the object in view. You know, there are some paras, may I just read these? I'm sorry, there are 8 or 9 paras of this judgment. Judicial scrutiny.
You have 5 minutes left.
My lord, then, my lord, then I won't read.
Or the others will have to curtail the time.
One of the most celebrated judgments.
So
of
very
democracy direct to
I'm
the
not reading it.
holders.
I'm not reading it. My lord, just 2 points here on this judgment. I'll just mention the points at least your lordship may permit me. Para 30, page 35, if your lordship just sees, the distinguishing features between the case and Roshan Lal is at para, my lord, 45 onwards.
Yes.
And Mervyn Coutinho is distinguished at para 49. Correct, my lord?
Yes.
Now, please now permit me to read para 41. So, my lord, now because it's saying on a reasonable classification, you can have a promotion within an integrated class. Now, my lord, please let me read para 41.
Para 40.
41. This honorable court in a 7-judge constitution bench, now this is a recent judgment of last year, State of Punjab versus Davinder Singh. So this is not a sub-classification judgment. While distinguishing the judgment in Roshan Lal and held that Triloki Nath is the leading judgment for the proposition that the integrated class can be further classified if there is intelligible differentia and if the yardstick used has a nexus to the object of the provision. Reliance in this connection has been placed on paras 88 to 90 and 308 to 310. But 88 to 90 was of the then Chief Justice and 308 to 310 is of my Lord the Chief Justice. And my Lord had in fact agreed and concurred with that.
Yes.
So, my Lord, I am saying 7 judges have now in a sense upheld Triloki. So there's no question of further reference as was being argued the other day. That's my submission. This is the position. Next, my lord, there is a judgment that I've cited.
That may not have any application. Look at page 50. that Lokinath Khosa applies this classification only on the basis of educational qualification.
Correct, absolutely right.
Not
No, no, now I'm saying, now experience as a classification, also I put a judgment. Experience being a valid ground for classification, for that I was just coming to that in fact, my lord. Please come to page 44.
42.
44, para 45.
Yes.
This is now, my lord, Jagannath versus Union of India. It has been held that classification based on experience is a reasonable classification. In paragraph 7, in so holding, Honorable Court followed the judgment in state of UP versus Chaurasia. And this is what Chaurasia says. Article 14 permits reasonable classifications founded on different bases. It is now well established that classification can be based on some qualities or characteristics of persons grouped together and not in others who are left out. These qualities or characteristics must, of course, have a reasonable relation to the object sought to be achieved. In service matters, merit or experience could be the basis for classification to promote efficiency in administration. This is the line I am relying on. Rest I will not. I'll just mention one judgment for Lordship's consideration, which is Kuldeep Kumar Gupta. It's a two-judge bench, but all these aspects have been considered in great detail. It's page 40 onwards of the submission. The paragraphs have been set out.
Paragraph 43.
If I read it, then it will take 10 minutes to do that. These are, my lord, the points for Lordship's consideration. Oblige.
Thank you. Yes, Mr. Giri. You are next in line. Okay. No, your list shows that you are prior to Mr. Giri. You are appealing for Kerala High Court.
Page number.
इसमें भी होगा ना?
Yes.
Permission?
We are all interveners, but I am representing promotees from state of Bihar.
Promotees from state of Bihar.
We have filed a separate written submission too.
So is this yours at page 1?
Is it placed where? Volume 1?
Volume 1's lordship,
Page 100.
169. I understand, sir, this is your
But
page 169.
Voila.
Girish. 169.
There is one physical compilation too, where the latest written submission which I could muster, I have submitted. I won't be taking lordships to
On
the
behalf of Rakesh Kumar.
Rakesh Kumar.
That's at page 168 of the.
168 of volume 1.
Right. 168 physical.
But I am not relying on the facts and figures. They have already been disclosed to lordships. There's no point in wasting lordships' time on that. Fact remains, insofar as state of Bihar is concerned, and along with couple of states from the facts as emerged from Amicus's written submission, there is a mixed kind of perhaps indication. In certain states, the roster application to seniority has caused a little problem, particularly in my state of UP, and perhaps in certain other states like Andhra Pradesh and all that. But in certain states like Bengal, Madhya Pradesh and all, perhaps the situation has not been that troublesome. It's been quite fluid. So I would not be relying upon the fact that the percentages of posts that have been occupied by the promotees and direct recruits, that may not furnish a very strong ground for perhaps suggesting a rule of seniority. My submission is slightly different in the sense that, Lord, prior to 2002, the rule of seniority invariably and universally followed was the date of substantive appointment with the date of entry into service, and therefore your seniority will count on from that date. That was what was said by the Constitution Bench in direct recruits case. So what your Lordship said, that date of vacancy is not relevant. Retrospectivity cannot be given to the appointment. So the critical factor was date of substantive appointment into service. That would be the commencement of your seniority or the reckoning of seniority. It was in 2003, as a consequence of Shetty Commission's recommendation, Lord, that the Lordships changed the rule of seniority. And perhaps it seems the Lordships were impressed by Sabharwal's case, the enunciation of a roster application, and applied that to seniority. Not when this was done, Lord, when this seniority rule was changed, Lord, what was not pointed out to the court was, Lord, that Sabharwal case is a case which is of a single selection. In other words, that was a case where promotees of different castes were vying with each other for, under different quotas, were vying with each other for promotion. So it was a single selection taking place simultaneously for everyone, and therefore adjustments could be made. It could be made through roster also, there was no difficulty. But in our case, tragically, my lord, the selection is threefold. One by direct recruitment, the other by the LCE category, and the third is by promotion. And all the three selections take place at different points of time. Sometimes direct recruitment doesn't take place, sometimes the promotion is delayed and so on and so forth. And consequently, then it becomes difficult to adjust by operation of the same roster. And what I borrow and which fell from Lord Justice Surikant was that the difficulty is arising when you start adjusting people who are promoted in the next calendar year into the roster and allow them to score a march over the others. One factor has to be kept in mind is that date of entry into service cannot be wiped away. We cannot go by the period of selection or the commencement of the selection or the advertisement of vacancy and all. That cannot count for the purposes of seniority, because otherwise we'll be giving retrospectivity to the appointment or promotion. Now, keeping this factor in mind, that retrospectivity beyond the date of a substantive appointment cannot be given, then we must, and we have to consider how to apply the roster. Roster can only be applied, Lord, if a Lordship would see, the Lordships in Sabharwal in the 2002 case, Lord, followed Sabharwal's case without looking into the fact that it was only single selection, and therefore there was no difficulty in applying the roster. They applied it here. But the difficulty here was a threefold selection which were not being held simultaneously. And this difficulty was felt by Malik Mazhar Sultan, 2006 and 8. And therefore, their Lordships recommended a time schedule simultaneously starting and concluding, so that all the three conclude at the same time, and then the select list is indicated, and then the appointments are made. Therefore, the year of recruitment would always be the same. And then you can adjust it in the roster conveniently without any difficulty. Or the other thing could be perhaps that you hold the separate selections separately and wait the select list till all the 3 selections are concluded, and then issue appointment letters. There may be a gap of 6 months, 5 months, or maybe 10 months between the 3 categories of selection. And then thereafter appointment letters are issued. That perhaps will reduce the difficulty in fitting it seniority via roster. If this cannot be done, Lord, then the only way possible, in my submission, respectful submission, is keeping the first factor in mind that no retrospectivity can be given to the appointments. The only way to adjust seniority via roster is that we have to run the roster year-wise. For instance, supposing not selection commences, any selection commences, direct recruitment or promotion or otherwise, and it will always be the effort of the court and lordship that the selection would start, all the 3 selections should start simultaneously, close by. Now, once the selection starts, the roster revives. So roster comes into being, and roster has to be yearly roster. It can't be roster for n number of years. And that is where the problem which Justice Surikant pointed out will arise. If the roster runs year-wise, then supposing the direct recruitment takes place in 2018, and for some reason or the other, administrative reason or the other, a difficulty or maybe a challenge, something like that, that they postpone the other tests or other selections are postponed to the next calendar year. Then the person who gets appointed in the next calendar year cannot be fitted into the roster points of this recruitment year. This recruitment year must end by 31st of December if it is calendar year. And the roster can run only till then. Whoever is appointed, direct recruit, promotee, or LCE, whoever it may be, he will be fitted as per the roster and will be there in the cadre of the additional district judges. The others who come later on next year, supposing the exams or the selection of the promotees is perhaps extended to the next calendar year, then the roster of next calendar year will have to be adopted and utilized. It can't be the earlier year, because then otherwise difficulty is, for instance, in the case of Bihar. What happens is the first 3 posts go to the promotees, the 4th goes to the, as per the roster, to the direct recruit. And then again 5, 6, 7, and so on and so forth. Now, if we, supposing the promotees promotion is not concluded in the calendar year, then the difficulty would be how to fit the direct recruit, because he's at item 4. And the promotees who get selected in the next calendar year or recruitment year, they come and occupy space before the direct recruit, and that can be vice versa also. So what I suggest, with humility, that lordships must look into this aspect, that the roster operation has to be yearly. It cannot extend beyond the calendar year or the recruitment year. Whatever recruitment takes place in any of the categories, they have to be fitted as per the roster.
According to it cannot be carried forward.
You can't be carried. Because the moment you start carrying forward, then the discrepancy and the haphazard allocation would start coming in. For instance, let's take a case, 3 promotees are appointed in 2018. The direct recruit selection couldn't conclude by 2018. Then we can't fit, next year when the promotees come in, or the remaining promotees of 2018, they can't be fitted into the roster because direct recruit occupies the 4th place. He gets selected in 2018, comes and sits over the other promotee. So that haphazard and perhaps incorrect, inappropriate application should be avoided. And the only way to avoid is to run the roster till the end of the year, and then whoever gets appointed for whatever reason, whoever gets appointed next year, he should come and fit into the roster of the next year, so that he will always be junior. The basic rule is someone who comes into service in the succeeding year cannot not precede the person who's already been appointed substantively on his post in the earlier year. The person in the earlier year will always be senior to the one who's appointed subsequently. So this broad application of roster perhaps would resolve all the controversies with regard to the seniority aspect. Lord. Now coming to the other aspect, Lord, the promotees, because the Lordship has seen the difficult position of the promotees, particularly in my state, UP is also, and certain other states, Rajasthan, Gujarat, they're all having the same, suffering the same fate. So what I submit with respect is, Lord, that there is no doubt that once the selections to the post of additional district judge or district judge entry level, we in UP called it more additional district judge, but in perhaps Bihar it is entry level district judge. Once they are appointed, they merge in the common cadre. There can be no dispute about that fact. I am not saying create a class within the class for further promotion. That's not the case. All that I'm saying is that since there are quotas prescribed for district judges level posts, it would be appropriate to facilitate the smoother transition to the higher category of posts by giving separate quotas commensurate to the population of the judge in the cadre. For instance, promotees, they are 50%. So you can give the quota of 50% in the principal district judge category. Likewise, about 25% direct recruits, they can get the quota of 25% in the principal judge category, and so LCE and so forth. What happens here is that we are not categorizing or classifying, or we are not denying anyone the promotion. They're all getting their due chances within their the population which the sphere which they occupy in the post of district.
But would it not be unfair to those coming through limited competitive?
No, they will also get 25%.
They get 25%.
They'll get.
They, on account of their own merit,
No, they
have come earlier in the cadre of district judges.
But can you bear in mind, as pointed out by my friend Rod?
They are again pushed back. So those persons who are enjoying the office without trying for competition to excel themselves, they will get it as a bounty.
No, then they have their own quota in which they can go up. It's not that the quota is not blocked at the top. Quota is open at the top. 25% LCE, that's an incentive given to those who want to get the faster promotion and are meritorious, more meritorious perhaps. Then they have their quota within which they can go 25%. And 25% would be more than adequate to accommodate all the LCEs. The Lordships have seen the data Lordship has seen. Lordship would not get so many LCEs who can go over 25%. Likewise, on the other hand, look at the promotees. They form the bulk of the population in the cadre of district judge. And yet, from 26. The fact is, from 2026 onwards, there would be no principal district judge in state of Bihar belonging to the promotee cadre, 50% quota. There would be no till 2035. And what will happen thereafter, we don't know. So the question is, at the moment, there are 90 principal district judges, out of which 85 perhaps approximately are the direct recruits, and 4 or 5 I think perhaps are
91, 86 and 5.
Now look at this, as a skewed consequence. The 50% of the population has only 4 seats, while the 25% of the population.
Because of that anomalous situation. 7 years, no recruitment.
But that anomalous situation happened. That anomalous situation happens even in the promotee cadre, because we got recruited in 2001. We got promoted as civil judge senior division in 2014, and then 2018 as district judge,
yes,
and entry level. So it has taken nearly 17 years for us to reach that stage. And at every stage, we have been considered to be meritorious to be selected for the higher grade. So it's not that we were worthless kind of, or the deadwood, as the lordships call it. So looking into this, my suggestions are twofold. One, let the seniority be determined on the basis of roster. For instance, in this case, in the state of Bihar, May 2018, direct recruits got recruited into the cadre. And in December 2018, the promotees got recruited into. Now, both came in 2018. So it won't be a very big catastrophic loss to anyone if 4 or 5 months loss here and there, but at the same time, you can adjust them very conveniently into the roster of that year. Now, if we start counting seniority by month and days, perhaps they may have a cause. But the fact remains, it can't be done. Not we are looking at the overall picture, how to run the system smoothly. So there, some casualty here and there will be there. So, but by and large, this system of running the roster per annum will reduce the friction to the minimum and let the system function smoothly. Add to that the quota for the principal district judge category post. For the separate categories, there is no classification as such. Lokinath Kosa's rule will not apply here. There the rule was that the person who could have otherwise secured promotion, if there was no rule prescribed for higher education for further promotion, then he would have secured further promotion. So by this prescription of qualification, additional qualification, he got denied the opportunity. But here there is no denial of opportunity. We are giving commensurate quota to each category depending upon what the quota was in the earlier category.
So if the roster is to operate annually, the direct recruitment process starts, let us say in July. In June, July, we issue the advertisement, invite applications, hold preliminary exam, then written main exam, then interviews. And by that time, you are somewhere near end of the December.
Man.
Someone files a petition in the High Court, the declaration of result is stayed.
That happens.
Right? 31st December passes, New Year comes, writ petition is dismissed, found to be frivolous. What will happen in that case?
No, they are not in that particular list. Your lordship can always grant a decree or an order that can restore the loss of order.
Deeming fiction will have to be created.
Not
That for
fact
all
is
intents and purposes,
quite,
but for an unforeseen circumstance,
quite right.
they would have been appointed.
Quite right.
So therefore, you will create a
I
deeming
mean, that
fiction.
very often lordships do, my lord. If consideration has not been done
So the
timely, then
argument-
lordships direct that they will be considered with effect from that.
The other side argument will be that if you have an annual roster and you fail to hold examination for any reason, not only fail to exam, you hold the exam, but if you fail to make an appointment for any XYZ reason,
Man.
why eventually the finally selected candidate should suffer?
Not, may I answer this, bro? We cannot bring about any perfect system. Your lordship would never have that. There will always be a dispute. And people will dispute. We have been seeing it right from the days of Patwardhan Lord till date. Lord. Some dispute or the other comes whenever there are twofold quotas. But the issue and the idea which I am suggesting is to have the minimal friction, minimal disturbance, and minimal heartburning on either side, all the three sides. There would be some, there's no difficulty in that. There would be some which will require resolution, spot resolutions and things like it as and when it is required. But the fact remains, by and large, things should proceed smoothly. As the lordship said, not 2018, if this direct recruitment concludes, he will be the direct recruits will be adjusted against the roster of 2018. But on the other hand, the bigger anomaly occurs, as the lordship noticed, not that if we start adjusting people of 2018-19 selection in the year roster of 2018, then it becomes a little more anomalous. So let's see where perhaps the least amount of friction, least amount of heartburn, and least amount of difficulty is there. Obviously, we cannot have a perfect system. That is what I am suggesting. And coupled with the quota at the top, perhaps each segment will proceed smoothly in its own That's my submission.
All right, yes. Yeah.
Yes, Mr. Pati.
I'm grateful, Lord, and then before I end, Lord, there's one apology of mine, Lord. Sincerely, Lord, I must say, because on the last occasion I had mispronounced, Lord, Justice Chandran's name, Lord.
No,
So I'm extremely sorry for that.
N is an addition we have in South India. No big deal.
Well, that can be sorted, Lord, sorted out over a cup of tea or coffee also. I'm grateful.
Please, Your Lordships. Your Lordships, I'm appearing for the LCE category, Your Lordships.
For the
LCE category, Your Lordships. Unfortunately, in this whole battle, Your Lordships, we are the grain which has been sandwiched between the two stones. And the benefit which was supposed to come to us as an incentive, Your Lordships, is not coming to us for the basic fallacy of every High Court treating us as a part of the promotee group. Now, Your Lordships, from All India Judges 3 onwards, there are 3 categories.
Belong to which category?
LDC.
LDC.
LDC. Your Lordships, from All India Judges number 3 onwards, 3 streams have been created. So, in terms of considering for making the cadre of district judge, there are 3 streams. There are not 2 streams, direct recruit and promotees. There are 3 streams which are direct recruits, LDCE and promotees, Your Lordships. What has changed over the years, Your Lordships, from the 2002 judgment to 2025 judgment is only the numerical quota of LDCE, which is 25%, then it came down to 20% and now 10%, and now it has gone back to 25%. But the concept with regard to it being a separate and distinct category has not been obliterated since 2002 onwards, Your Lordships. Now, for that purpose, let me just point out, Your Lordships, 2 or 3 concepts which are required for the purposes of clarity, Your Lordships, how the seniority list must operate. First of all, Your Lordships, the feeder cadre for the post of district judge entry level is what has to be taken as a unit. The unit is not the further promotional posts in the district judge cadre. So when we are looking at the cadre, as per all the High Court rules, which I will show to your Lordships, the cadre is of higher judicial services cadre. And it is the post of the entry level that we have to look at, where the seniority and gradation list will be made. Thereafter, Your Lordships, it will move in accordance with that basic entry level seniority list. The further promotions will be on basis of that. So that is the first thing, Your Lordships, that the cadre has to be at the entry level. The second aspect that, Your Lordships, is that how do we rationalize and ensure that no category out of these 3 categories steal a march or are left behind for certain administrative exigencies. As we have discussed, Your Lordships, it just fell from Lordship, that for some reason, suppose a promotion DPC doesn't happen. If there is no promotion which is done for the next 3 to 4 years, as what happened during COVID period, Your Lordships, there were promotions which were due but could not be given because of the administrative purposes. Then at whose peril will that period, which has a valuable period, which we have lost, Your Lordships, at whose peril will that period go? So that anomaly has to be adjusted. And how that has to be adjusted, Your Lordships, is my learned friend, learned amicus, has suggested 4 alternatives, Your Lordships. In my respectful submission, Your Lordship, each of the alternative is I'm sorry to say, a half measure. It is not a complete solution to the problem that we are facing. Many high courts have rules, and I'll just point out to your Lordships, where the rules are on basis of cadre, rules are on basis of roster. However, they have not been applied consistently by the High Courts. It fell from Justice Bagchi that the problem that is arising is not the methodology, but it is the application of the methodology. And I will show that also, Your Lordships. So the third aspect is this aspect, Your Lordships, that how is the quota to be worked out? Next aspect, Your Lordships, is whether it has to be worked out on the basis of post or vacancy. This is also a well conceptualized legal concept, Your Lordships. I'll give those judgments that the roster has to operate on basis of post, which Your Lordship has also taken in account in the 2025 judgment of All India judges, that the vacancy will be filled up from the same category where the vacancy arises, Your Lordships. Like we just discussed, Your Lordships, if there is a retirement, suppose there is a death, suppose there is no further promotion, then those vacant posts on the roster points arise. Those will be filled according to the category to which the roster point belongs. Next aspect, Your Lordships, is All India Judges 3. The basis of All India Judges 3, Your Lordships, for adopting R.K. Sabharwal was that in R.K. Sabharwal, which is the locus classicus, the caste-based roster was the workable method by which now, as per the experience, Your Lordships, has not been faulted at all. The method of the roster is working perfectly. And in that also, Your Lordships, we have multi-layered quotas. One will go to the general category. Next will go to SC, ST, OBC. So these are four broad categories in which the roster works, Your Lordships. So the roster system, by administrative experience, has been working very efficiently in that caste-based reservation. And that is why Lordships imported the roster system by All India judges, the third 2002 judgment, Your Lordships. That having been imported, Your Lordships, the rules were made by various high courts after 2002. However, now the problem that has arisen is whether continuity in service is to be the criteria for the seniority to be adjudged. Some high courts do prescribe continuity of service. Some high court says that it shall be irrespective of continuity of service. So length of service in the feeder post, some high courts have said that it will be considered to put you in the seniority list. In some high courts, they have said that it will depend on the roster point, irrespective of the dates that you come into the position. The argument that is raised against this by direct recruit, Your Lordships, is that you're not even born in the cadre. So continuity of service is the best method to adjudge your inter se seniority. If you are not born in the cadre, you have not been appointed to the post of district judge, you cannot seek seniority over a previously appointed direct recruit. Suppose I'm a promotee, Your Lordships. My promotion batch comes in 3 batches delayed, Your Lordships. But direct recruitment has taken place, the advertisement has gone out, and the appointments are made. I am due for promotion, say, in 2000, Your Lordships, but my selection process does not take place in 2000, it takes place in 2003. So the 3-year gap, then I come under the rank of the direct recruit person who has come in 2000. So what Lordships have said is that the period of continuous officiation will not be the criteria. Your seniority in the cadre will come according to your roster point. So if a promotee came at roster point 10, then even if I have come in 3 years later, I come in point number 10. And direct recruit comes under point number 11, then even if he has come in 2000, he comes at point number 11. This is the inter se seniority roster, which has been, the mechanism has been devised, Your Lordships, and also has been followed in various rules. Now, the second, another aspect of this, your lordships, is that with regard to LCE particularly, there are 4 judgments I want to show to your lordships, where there have been conflicting aspects which have been considered by lordships, and there is no clarity. Therefore, your lordships will be required to give us clarity as to which of the 3 options is the correct option, which must be followed, which will be the most efficient option, your lordships. So I will just point those 3 judgments out to your lordships. Then comes the aspect, your lordships, within, now these are three categories at the same level. Now, within the promotees itself, what will be the seniority? What will be the basis of seniority? Now, between these 3 categories, your lordships, merit is the basic criteria, is the primary criteria, and that is why it is being incentivized for the LCE category. So when the merit is incentivized, your lordships, how is it incentivized on ground, your lordships? It can be incentivized only by me climbing the ladder higher, faster. But if I take the exam, I do very well in the exam or do badly also, but I clear the exam, your lordships, and I remain at the same position in the promotee list, your lordships, then there is no incentive for me to better my skills, your lordships. And from practical state-wise aspects, I can show to your lordships that promotees who took LCE exam, they are actually coming lower in seniority than higher in seniority. And I'll show from UP, because I'm appearing in the UP matter, your lordships, that they have come down in seniority. So many of them, what your lordships have found, that people are not taking LCE exam. They are not taking it for the purpose, because in promotion, they are rising faster.
But that now we have resolved.
No, your lordships.
Yes, because earlier they could not appear before completion of 10 years.
Correct.
Now we are reduced to 7 years.
That is one aspect. The second aspect, your lordships, is that despite my being eligible for taking the LCE exam, despite that, your lordships, now age, etc., has been resolved. But where do I fall on the seniority list? I'm still at the bottom of the seniority list. The pool, your lordships, have resolved, that the pool will become bigger.
If somebody, suppose A passes LCD.
Yes, your lordship.
And gets promoted in 2020.
Yes.
The juniors will be, who are promoted subsequently from the promoting cadre will be always junior to him.
Your lordships, I'll show from the actual application, your lordships, that is not what is taking place on ground. Your lordships have set it out. Lordships have said that the rules will be formulated. Rules are formulated, but what is happening, your lordships, that the High Court are now using the roster year-wise or recruitment-wise.
This must be happening on account of the perceived strict observance to the roster point. That irrespective of you, as Honorable CJ has pointed out, that irrespective of you qualifying in 2020.
Please, your lordship.
And at say particular roster point, say for example you are 12.
Yes, your lordship.
And the ordinary promotees, merit cum seniority promotees, if they have a roster point number 10 and 11.
Please, your lordship.
So even if they are promoted in 2023, they are being placed at 10 and 11, and
Please.
resultantly you are stuck at number 12. That might be happening only because of misconstruction or misapplication of the roster.
I'm most grateful, your lordships. That is one of the reasons. And the other reason also, your lordships, is
so most of the cases, the seniority is being roasted by this roster.
your lordships,
Take it back to the date of vacancy.
your lordships is absolutely right. Why that is happening is because it is controlled. The roster is not controlled as a running account on the basis of cadre strength, but it is controlled by recruitment. So the roster breaks. In the first year, suppose there are 20 recruitments, your lordships. After number 20, it restarts from number 1. Whereas it has to continue with number 21. So that is where the breakdown is happening. That it is selection-wise or year-wise that the roster is again put into play. So therefore, lordships will notice that normally in all high courts, I'll show the appendix, in the roster you have first 3 direct appointments, next 2 promotees, and the last, your lordship, LCE. So or it varies from different, the numerical or the this thing, but usually direct promotee is the number one in most of the rosters which have been prescribed. Now, unfortunately, what is happening is that suppose 10 people have been selected in a particular year, your lordships, again, direct recruitment come in the roster, higher in the roster, the next selection. So the breakdown is happening at that particular point. The breakdown, it is not that the rule is not providing. The rule is providing, but the way it has been applied, your lordships, at least in Uttar Pradesh, your lordships, is for this reason that it is applied on basis of continuity of service and it is applied selection wise. It is not applied cadre wise. Then the last thing that I want to bring your notice and attention to your lordships is, which is where there'll be some guidance which will be required by your lordships, is with regard to the selections which have taken place post 2002. Now, in 2002, your lordships had given them time to implement it, to amend the rules. The rules got amended. But again, our complaint is this, that the rules were not being followed as per the amended aspects, your lordships. So what about the selections which have taken place after 2002? Because in 2002 itself, it was mandated by this honorable court that this will now apply prospectively. Then from 2002 onwards, your lordships, my humble submission is that all selections which have taken place post 2002 have to be in accordance with the guidelines which have been given by your lordships in All India judges and what your lordships will decide today, your lordships. So that date, cutoff date, on basis of which the seniority must be drawn in the cadre, your lordships will have to consider and give that guidance, that what will be the date from which, because your lordships have, in all orders and judgments, even in 2025, your lordships have said that this will apply prospectively, the 25%. Then lordships have also said we'll amend the rules. The shortfall is not amendment of the rules. The shortfall, your lordships, is the application of the rules. Now, your lordships, shortly, I will just point out, if your lordships will just take R.K. Sabharwal for a moment, your lordships. Lordships will find it. Volume. Your lordships, volume 5A, page 360. Lordships, it's a short, concise judgment which is holding forth even today. Your lordships, it has withstood the test of time.
360.
360, your lordships. Volume 5A.
Not the volume you provided just now. No.
No, your lordships, that's 6. That's volume 6. This is the Nodal Council's volume 5A, your lordships. Yes. Page 360.
Which judgment?
R.K. Sabharwal, your lordships.
Yes.
Now, my submission, your lordships, with regard to R.K. Sabharwal is that, your lordships, this lays good law and it is a 5-judge bench judgment, your lordships, and that must be followed again and has been followed, and there is no cause to differ from this, your lordships. Lordships may kindly come to paragraph number 5. This was with regard to the Punjab Engineering Services, your lordships. And here the dispute was with regard to interstate dispute between promotees and direct recruits. The lordships have the SCR copies. Yeah. What is this? We see considerable force. Your lordships will come to page 369, placitum D.
369.
Please, your lordships.
Lords, I have a suggestion. Volume 3R has the SEC volume of Sabharwal. because I think if Ms. Makija is referring to para numbers, that may be more helpful. R3.
Thanks. Lordships may, I'm just reading the portion which is relevant. Your Lordships may mark it, it's para 5 in the SCC and it is placitum D at page 44. Internal 44, placitum D in the SCR. We see considerable force in the second contention raised by the Learned Counsel for petitioners. The reservations provided under the impugned government instructions are to be operated in accordance with the roster to be maintained in each department. The roster is implemented in form of running account from year to year. The purpose for running account is to make sure that SC, ST and OBCs get their percentage of reserved posts. The concept of running account in the impugned instructions has to be so interpreted that it does not result in excessive reservation. Then your Lordships will skip a bit and come to the middle of the paragraph where it is said, we see no justification. Lordships, then an example is given. And then if your Lordships will come to...
370 top.
Yes.
Yes, your Lordships, page 370 top. We see no justification. We see no justification to operate the roster thereafter. The running account is to operate only till the quota provided under impugned instructions.
This is once that is complete.
Yes.
Then the person, the vacancy filing will be filled in from that category alone.
Please, your Lordships. That is the principle. That's the clear-cut principle. And one more aspect which is clear from here, your Lordships, is whether it has to be according to the post or the vacancy. If your Lordships comes to the last portion of this paragraph, it says, the vacancies arising in the cadre after the initial posts are filled will pose no difficulty as and when there is a vacancy, whether permanent or temporary, in a particular post, the same has to be filled from amongst the category to which the post belonged in the roster. For example, SC persons holding the post at roster point 1715 retire, then these slots are to be filled from amongst the persons belonging to the SCs itself. Similarly, if persons holding the post at point 8 to 14 or 23 to 29 retire from these slots, are to be filled from among the general category. By following this procedure, there shall neither be shortfall nor excess in the percentage of reservation. Then your Lordships, next paragraph is with regard to the basis. What is the total strength on basis of which it will be calculated? It is the cadre strength and not the recruitment strength. The expression posts and vacancies, often used in the executive instructions providing for reservations, are rather problematic. The word post means an appointment, job or employment, a position in which a person is appointed. Vacancy means an unoccupied post or office. The plain meaning of the two expressions make it clear that there must be a post in existence to enable the vacancy to occur. The cadre strength is always measured by number of posts comprising the cadre. Right to be considered for appointment can only be claimed in respect to a post in a cadre. As a consequence, the percentage of reservation has to be worked out in relation to the number of posts which forms the cadre strength. Now, under the UP rules, your Lordships, the cadre is defined under Rule 2, I think, where it says that the service will be a single cadre called the Higher Judiciary Service cadre. So the cadre is the entry-level post that we are talking about. Then your Lordships, this has been now consistently followed. And if your Lordships will take 3 particular judgments with regard to LCE, where in my humble submission, 2 judgments are in conflict with each other, therefore Lordships will be required to resolve that conflict. Your Lordships will kindly take Punjab and Haryana High Court versus State of Punjab, your Lordships, volume 6, which we've just handed over, your Lordships. At page 288. Lordships, on a lighter side, when I was preparing for this, Your Lordships, Punjab seems to be having the supremacy in service law, Your Lordships. R.K. Sabharwal also, Your Lordships, this judgment also, which is the correct.
By supremacy, why only service law?
Service jurisprudence is all given by Punjab.
Yes, Your Lordships. That,
Why are you leaving Haryana?
Your Lordships, I'm just sharing an observation that I had.
You have to conclude.
Yes, Your Lordships. I-
5 minutes.